So now let's go to maritime crew claims. So this is for the disability benefits of seafarers. So the main rules and procedures on claiming disability benefits is generally found in Section 20A in relation to Section 32 of the POA standard contract. So you can type Google this POA standard contract for seafarers to to check. So the court explained in Vergara versus Amonia that a seafarer upon sign off from his vessel for repatriation in the Philippines must report to the agency or the CDP means company designated physician within 3 days from the arrival for diagnosis and treatment. So lumabas to sa bar, last bar. So itong 72-hour rule or 3-day rule. So for the if the seafarer generally if the seafarer failed to report to the company the agency or company designated physician within 72 hours, his claim will be not or the claim will be void or will not be processed. But though there are certain exceptions, but yeah, generally if you don't report 72 hours, so yan, you cannot claim for disability benefits. So for the duration of the treatment, but in no case that exceeds 120 days, the seaman is on temporary total disability. Temporary as he is totally unable to work. So temporary muna. He receives basic wage during this period until he is declared fit to work, or his temporary disability is acknowledged by the company to be permanent, either partially or totally, as his condition is defined under the POA standard employment contract and by applicable Philippine laws. If the 120 days initial period is exceeded and no such declaration is made because of the seafarer requires further medical attention, then the temporary total disability period may be extended for a maximum of 240 days. So, but however, this 240 days should be justified, subject to the right of the employer to declare within this period a permanent partial disability or permanent total disability already exists. So the seaman may of course also be declared fit to work at any time, and such declaration is justified by his medical condition. Medical finding. So the company designated physician shall give the disability grading within 120 or 240 days as the case may be, and should be compensated according to the table of disability grading in section 32 of POA SEC. So dun sa section 32 merong mga grading. So grade 1 total permanent disability, then mga grade 2, so may mga doon, may table of disability na kailangan na declare ng company designated physician. The disability shall be based solely on the disability gradings provided under Section 32 of the POA employment contract, and shall not be measured or determined by the number of days of the seafarer is under treatment or the number of days in which the sickness or sickness allowance is paid. However, the Supreme Court ruled in Kestrel that under Section 32 of the POA SEC is generally only for those injuries and disabilities that are classified as grade 1 and may be considered as total and permanent. However, the court also emphasized that the POA standard employment contract should be read in harmony of the labor code or the AREC. So AREC is the IRR of the labor code on disability benefits. So therefore, if those injuries and disabilities with disability grading from 2 to 14, hence partial and permanent, would incapacitate a seafarer from performing his usual sea duties for a period for 120 to 240 days, depending on the need of further medical treatment, then he's under the legal contemplation of total and permanently disabled. So dito nagkakagulo sa crew claims. Kasi may nagsasabi dapat yung grading under Section 32, but ito naman may sabi naman ibang sa iba sa Supreme Court na kahit grade 2 to 14 makakuha pa rin siya ng full compensation if the seafarer is unable to work for more than 120 or 240 days as the case may be. So findings of the company designated physician may be contested through the opinion of the second doctor appointed by the seafarer. If the second doctor disagrees with the assessment, a third doctor may be agreed jointly between employer and the seafarer. The third doctor's decision shall be final and binding on both parties. Okay, in pursuing an action for maritime crew claims, so if a seafarer wants to file a case, he must first determine whether he has a cause of action. So in CF Sharp versus Taok, the Supreme Court ruled that seafarer may pursue an action for total or permanent disability if the company designated physician failed to issue a declaration as is to fitness to engage in sea duty or disability even after the lapse of the 120-day period, and there is no indication that further medical treatment would address his temporary total disability, hence justify an exception to 240 days. So, or the 240 days had lapsed without any certification being issued by the company designated physician. The company designated physician declared that he is fit for sea duty within 120 to 240-day period, as the case may be, but his physician of choice and the doctor chosen under section 20B3 of the third doctor of POA Sec are of contrary opinion. So the CPD acknowledged that he is partially permanent disabled, but the other doctors who he consulted on his own and jointly by his employer believe that his disability is not permanent and but total as well. The CPD recognizes that he is totally and permanently disabled, but there's a dispute on the disability grading. So the company designated physician determined his medical condition is not compensable or work-related under PUA Sec, but his doctor of choice or the third doctor under section 20B of the PUA Sec found otherwise and declared him unfit to work. The company designated physician declared him totally and permanently disabled, but the employer refuses to pay him the corresponding benefits. Then last, the company designated physician declared him partially and permanently disabled within 120 or 240-day period, but he remains incapacitated to perform his usual sea duties after the lapse of the said periods. So where to file? So if there's a cause of action, the next thing to do is to determine whether his employment contract has a collective bargaining agreement or CBA. Contracts with CBA may give a higher maximum amount compared to the $60,000 threshold provided in Section 32 of the POA Sec. So it could reach as much as $250,000 depending on the CBA. So if you're going to practice, so crew claims practice is quite lucrative because of this nga, this is a contingent contingent arrangements. So malaki din yung kinikita ng mga lawyers who practice this crew claims, especially if you're for the seafarer. So in order for a contract to have negotiated the CBA, the principal should be a member of the International Transport Workers Federation or ITF with an affiliate maritime union. The most prominent among them here in the Philippines is AMOSUP, or the if the contract is with the CBA, so yung AMOSUP makikita nyo sa yun sa Intramuros. So if the contract is with the CBA, the first step is to bring the case with the grievance machinery of the union wherein the seafarer and the employer will meet for possible settlement. If the settlement is not possible, the grievance procedure shall be terminated. On the other hand, seafarers who have no CBA may file a request for assistance or RFA to DOLE, NLRC, and CMB, POA, and other parties will be the parties will be scheduled for SENA before a SENA desk officer for possible settlement. If the SENA fails, the SENA desk officer will endorse the case to the labor arbiter or to a labor arbiter. The parties will be scheduled for mandatory conference for another possible settlement. So proceedings before the voluntary arbitrator. So after a failed grievance procedure, the seafarer can file a notice to arbitrate before the National Conciliation Mediation Board, NCMB. Afterwards, the parties will be scheduled for a SENA before a designated conciliator mediator, CONMED, for another possible settlement. If the SENA failed, the parties will choose their voluntary arbitrators from the list of accredited voluntary arbitrators of the NCMB. So it could be a sole accredited voluntary arbitrator or a panel of 3. In the course of the voluntary arbitration, the voluntary arbitrators shall order the parties to submit their respective position papers and reply. And from there, they will make a decision. The voluntary arbitrators will make a decision. The aggrieved party may file a motion for reconsideration or file a petition for review under Rule 43 before the Court of Appeals. So, pag voluntary arbitrator, it is Rule 43 before the Court of Appeals, then Rule 45 to the Supreme Court. So, tandaan nyo yan. Pag voluntary arbitrator, Rule 43 to the Court of Appeals, then Rule 45 to the Supreme Court. So proceedings before the labor arbiter. So on the other hand, the seafarers who have no CBA may file the request for assistance before the already mentioned a while ago. Then however, due to the long line of cases where in-service third doctor were not availed in cases of conflict between CPD and the seafarers and personnel doctor, then NLRC and NBAC promulgated an NMAC resolution. So in pursuant thereof, labor arbiters are directed to give the parties during the mandatory conference a period of 15 days within which to secure the services of third doctor and an additional period of 30 days for the third doctor to submit his or her assessment. If the settlement is futile, the mandatory conference will be terminated and the labor arbiter will order the parties to submit their respective position paper and reply. From there, the labor arbiter shall make his or her decision. Aggrieved parties of LA decision may file a notice in memorandum of appeal within 10 days to the NLRC Commission proper. Afterwards, the NLRC shall order the parties to file its comment or opposition to the said memorandum. From there, the assigned commissioner shall make their decision. Aggrieved party may file an MR. So in contemplation of law, the decision of NLRC is final and executory. However, if there's a grave abuse of discretion, the aggrieved party may file from the resolution of MR petition of certiorari under Rule 65. Pero dapat may MR muna bagong file ng Rule 65 before the CA by virtue of St. Martin Funeral Homes. Aggrieved party of the decision may file an MR and Rule 45 to the Supreme Court. Tandaan nyo, if galing sa voluntary arbitrator, Rule 43. Pag galing sa NLRC commissioner or commission proper, it is Rule 65. Pero dapat may MR. MR is mandatory before you file Rule 65 before the Rule 65 before the Court of Appeals. So yan. So now we'll go to the BRION Doctrine. So we'll go to the school of thoughts on different interpretation on crew claims. So Justice Arturo Brion's major ponensya in this subject matter is Vergara versus Ammonia and Splash versus Ruizo. So which mostly favors the employer. And in Vergara, Supreme Court ruled that the sign-off of first vessel of the seafarer must report to the CPD within 3 days from arrival of diagnosis and treatment for the duration of the treatment, but in no case shall not exceed 120 days. The seaman is in temporary total disability as he is totally unable to work. If the 120 days initial period is exceeded and no such declaration is made because of the seafarer requires further medical attention, then the temporary total disability may be extended up to 240 days subject to the right of the employer to declare within this period after permanent partial or total disability already exists. The seaman may of course also be declared fit to work at any time of such declaration is justified by his medical condition. In the above ruling, the company designated physician within 120 to 240 days could have to declare whether the seafarer is permanently partial to grades 2 to 14 disabled or permanently total, so grade 1 disabled or fit to work, no grading. There is no permanently partial but unfit at the same time. So for BRION, there's no permanently partial but unfit at the same time. Also in Vergara, the court ruled that if the seafarer did not initiate to get the assistance from a third doctor, CPD's opinion will prevail even if the seafarer consulted his personal physician. On the other hand, the Supreme Court ruled in the Splash that the degree of a seafarer's disability cannot be determined on the solely basis of 120-day rule in total disregard of the seafarer's employment contract. So, POA SEC. The parties, CBA, if there's one in the Philippine law and the rules in case of any unresolved dispute, claim of grievance arising out of in connection with the POA standard employment contract. The court explained that the reason why this compensation system provided in the POA SEC is often ignored and disregarded is the fixation on 120-day rule and the notion that an unfit to work or inability to work assessment should be awarded permanent total disability compensation even when the seafarer is given a disability grading in accordance with Section 32 of the POA SEC. A note in Section 32 of POA SEC declares that any item schedule classified under the grade 1 shall be considered and shall constitute total and permanent disability. Any other grading therefore constitutes only temporary total disability. Considering that POA standard contract embodies the terms and conditions governing the employment of Filipino seafarer on board ocean-going vessels, it's about time to schedule of disability compensation under Section 32 seriously observed. A step toward this direction had been already taken by way of court's clarificatory resolution in Crystal Shipping, where it declared the POA SEC does not measure disability in terms of number of days but by gradings only. So that's BRION Doctrine. So to summarize, BRION Doctrine states that awards for disability benefits should not be based on the number of days or unfit to work or inability to work by physicians, but on the compensation system provided by Section 20 and Section 32 of the POA SEC. BRION Doctrine also gives more probative value in the opinion of company designated physician than seafarer's personal doctor in absence of the opinion of the third doctor or seafarer's initiative to get the services of the third doctor. And rulings in Vergara and Splash were also adopted in a Philippine Ship Agency Incorporated versus Dumagdag, Pilman versus Kabanban, Racelis versus UPL, and Walem versus Quilano. Now let's go to Reyes Doctrine. So it mostly favors seafarers it is by Justice Benvenuto de Reyes in his famous Penencia, Kestrel versus Monar, declaring a POA SEC should be read in harmony with the labor code and the AREC, the implementing rules, and explained that the 120 days provided under Section B3 of the POA SEC is period given to employer to determine fitness to work and when the seafarer is deemed to be in a state of total and temporary disability. The 120 days of total disability may be extended up to maximum 240 days, and the seafarer require further medical treatment, and total and permanent disability becomes permanent when so declared by the company designated physician within 120 to 240 days, as the case may be, or upon the expiration of the said periods without the declaration of either fitness to work or permanently disabled, and the seafarer is unable to resume his regular seafaring duty. The Supreme Court also said in Kestrel that under Section 32 of the POA SEC, only those injuries or disabilities that are classified as grade 1 may be considered as total and permanent, but those injuries or disabilities with the disability grading from 2 to 14, hence, a partial and permanent would be incapacitate the seafarer from performing his usual sea duties for a period of more than 120 to 240 days, depending on the need for the further medical treatment. Then he is under legal contemplation, total and permanently disabled. Under Section 2B of the IRR, likewise provides that a disability or total and permanent if the result of injury or sickness of the employee is unable to perform any gainful occupation in continuous period exceeding 220 days except otherwise provided by the Rule 10 of the IRR. The phrase would incapacitate a seafarer from performing his usual duties was delivered from the definition given by the Supreme Court in Marcelo versus 7-Up, which declared that total disability does not mean a state of absolute helplessness, but means disablement of an employee to earn wages in the same kind of work or a work of similar nature that he was trained for and accustomed to perform any kind of work which a person or his mentally and attainment could do so. So the phrase does not mean The state of absolute helplessness was also used in Reyes Ponencia in Ayana versus PTC, PTC versus Cristino, where the court in this former declared that total disability does not mean the state of absolute helplessness, but inability to do substantially all material acts necessary to the prosecution of a gainful occupation without the serious discomfort or pain and without material injury or danger to life. In disability compensation, it's not the injury per se, which is compensated, but it's the incapacity to work. An earlier ruling related to Castel versus Iloreta versus Toquestel Oloreta versus Philippine Transmarine, where the Supreme Court applied the labor code concept of permanent total disability to Filipino seafarers in keeping with the about policy of the state to give the maximum aid and full protection of labor. It holding that the notion of disability is intimately related to the worker's capacity to earn what is contemplated being his injury or illness, but his inability to work resulting to the impairment of its earning capacity. Hence, disability should be understood less on its medical significance but more on the loss of earning capacity. So last is the so-called 120-day rule, was derived in Crystal Shipping Lines versus Natividad, where the Supreme Court held that permanent disability is inability of the worker to perform his job for more than 120 days, regardless of whether or not he loses the use of any part of his body, and that it is of the no consequence that the seafarer recovered from his illness or injury, for what is important that he was unable to perform his customary work for more than 120 days, and this constitutes total permanent disability. So to sum it up, Reyes Doctrine provides that as long as the seafarer is incapacitated to do his usual sea duty within 120 to 220 days, if declaration is made that the seafarer requires further medical attention, regardless of the grading, he will receive the disability award of equivalent to grade 1. Reyes Doctrine was also adopted in Alpha Ship Management Corporation versus Calo, Pride Shipping versus Balasta, Sea Lanes Marine Services versus De La Torre, PTC versus Cristino, and Maunlad versus Camoral. On the issue of probative value of the physicians, there is doctrine is silent on or not consistent on that issue. His ponensya on Sea Lanes Marine Services versus De La Torre said that where a seafarer was required a medication for beyond 240 days and remain unable to perform his customary work during the time rendered unnecessary any further need by him to secure his own doctor's opinion that a neutral third doctor to be determined the extent of his permanent disability. While in Inaya versus PTC, the High Court held that although the company designated physician already declared the seafarer fit to work, the seafarer's disability is still considered permanent and total if such declaration is made belatedly. If it is made for more than 120 days after repatriation. So other rulings on the probative value of physician's opinion. So however, there are Supreme Court decisions that give more probative value to the seafarer's personal doctor. In HFS versus Pilar, the Supreme Court held that the findings of the independent physicians were given more credence than those of the company designated physician, because the certification of company designated physician defeat the respondent's claim, while the opinion of the independent physicians would uphold such claim. The law looks tenderly on the laborer, where the evidence may be reasonably interpreted in two divergent ways, one prejudicial and the other favorable to him. The balance must be tilted in favor consistent to the principle of social justice. In PTC versus Cristino, the Supreme Court discounted the statement by the company physician that the seafarer's illness is not work-related for being self-serving, especially when there's a reasonable ground to believe that the latter's working conditions contributed in the development of his illness. Seafarer's personal physician's medical opinion deserves greater evidentiary weight as the petitioners offered no other convincing proof to substantiate their arguments despite the absence of their third doctor's medical opinion. In Carcedo versus Maine, the Supreme Court have a quite different ruling. It explained that even if the CPD had provided the disability grading, but the seafarer was required to continue medication and the CPD did not give his or her final assessment, it will result to a total permanent disability of the seafarer. The said initial assessment of the CPD is not binding since the seafarer was not required to continue medical procedure. So lastly, in the ruling ng Supreme Court in Leonis versus Navigation versus Obrero, explained that the difference on the doctor's opinion about disability grading and work-relatedness, in the former referral to third physician in case of contrasting medical opinion between CPD and the seafarer's appointed physician is a mandatory procedure that must be expressly requested by the seafarer, while for the conflicting opinion on the work-relatedness, a third doctor is not necessary because nothing in the POA section mandates that opinion of the CPD regarding the work relation should prevail, or that the determination of such relation must be submitted to a third physician. In the case, Supreme Court gives premium to the finding of the CPD on that illness the seafarer is work-related, not because they are infallible. Rather, it is because the assumption that they have closely monitored and actually related the seafarer and are therefore better positioned to form an accurate diagnosis. In cases where the seafarer's own physician had a similar opportunity to observe and treat the seafarer, the assumption is no longer holds, and the conflicting opinion stands equipoise. In such instance, tribunals should closely scrutinize the conflicting medical findings. So conflicts on disability award, according to the BRION Doctrine, disability award shall be solely and should not on the on the compensation system, should be based solely on the compensation system provided in Section 20 AC and Section 32 of the POA SEG, that the number of days of disability or unfit to work or inability to work assessments by petition should not be considered at all. In the contrary, Reyes Doctrine provides that regardless of the disability grading provided in Section 32, as long as it is determined that the seafarer is unfit to work or unable to work for sea duty for 120 to 240 days, if declaration is made that the seafarer requires further medical attention, the seafarer is entitled to award equivalent to grade 1 or total and permanent disability. And BRION Doctrine is heavily anchored on the provisions of the POA SEC because it is the contract and considered the law between the parties. Section 20A 2 of the POA SEC clearly provides that the disability shall not be based on the disability grading provided in Section 32 of the contract and shall not be measured and determined with the number of days shall be determined under the Section 32 and should be not determined or measured by the number of days a seafarer is under treatment or the number of days which the sickness or allowance is paid. Section 32 of the said contract clearly provides that in any item in the schedule classified by grade 1 under grade 1 shall be considered and shall constitute total and permanent disability. On the other hand, Reyes Doctrine is heavily anchored on the provisions of the Labor Code in its implementing rules, the AREC, and the jurisprudence regarding workers' compensation. The Labor Code, being a legislation and minimum requirements of employment according to the doctrine, should not be disregarded, but in effect, the disability grading provided in Section 32 is good as useless. So, Article 198 of the Labor Code, as amended, provides that the employee is considered total and permanent disabled if his disability lasts continuously for 120 days. In addition, according to the 2A of Rule 10 of the AREC, its implementing rules, it can extend up to 240 days where the injury or sickness requires medical attendance. Section 2B of the AREC likewise provided that the disability is total and permanent if as a result the injury or sickness of the employee is unable to perform any gainful occupation or a continuous period exceeding 120 days except as otherwise provided in Rule 10 of the AREC. In definition of the total disability from jurisprudence suited from Marcelino versus 7-up, the court held that the disability does not mean a state of absolute helplessness, but means this disablement of the employee to earn wages in the same kind of work or a work similar nature that he was trained for or accustomed to perform any kind of work which the person or his mentality or attainments could do. To illustrate the conflict, for example, if the seafarer who was assessed by the company designated physician with a grade 2 disability grading but with an annotation of unfit to work for sea duty for 1 year, the two doctrines will have a different point of view on how much disability benefit shall be given to the said seafarer. Applying the BRION Doctrine, the seafarer is only entitled to 88.81 of $50,000, which is 44 more or less $44,000, because this is what the Section 32 of the POA Sec provides. On the other hand, applying the Reyes Doctrine, the seafarer shall be entitled to 120% of $50,000, which is $60,000, applying the definition of disability, which means disablement of the seafarer to earn wages the same kind of relation in 198C1 of the Labor Code. The seafarer is entitled to full compensation because he cannot work for a year because it's more than 120 days as a seafarer. In BRION Doctrine, the seafarer is in that case only considered as partial and permanently disabled only in Reyes, the seafarer is considered as total and permanently disabled. So magkaiba sila ng interpretation. So conflicts on ideas on probative value of physician's opinion. The main issue here is whether the physician's opinion should have more probative value in the absence of the third doctor's opinion or the seafarer's initiative thereof. BRION Doctrine rulings are inconsistent on the rule that in the absence of the opinion of the third doctor or lack of seafarer's initiative to get the service of third doctor, the opinion of the CPD shall prevail. However, in the cases of HSF Philippines versus Pilar, PTC versus Cristino, the Supreme Court held that the findings of the independent physicians were given more credence than those of the company designated physician, because of the certification of company designated physician would defeat the respondent's claim, while the opinion of the independent physician would uphold such claim, and the CPD's pronouncement of non-work relatedness of the seafarer's illness is self-serving respectively. So a new Supreme Court case, Leones Navigation versus Obrero, explained that the difference on the third doctor's opinion about disability grading and work-relatedness. And the former, the referral to third physicians in the case contrasting medical opinion between the CPD and the seafarer's appointed physician, is a mandatory procedure that must be expressly requested by the seafarer, while the latter, for the conflicting opinion on the work-relatedness, the third doctor is not necessary, because there is nothing in the POA Sec which mandates the opinion of the company designated physician, and not necessarily because there is not company designated physician regarding the work relation should prevail that the determination of such relation be submitted to the third physician. The conflicting opinions in that case is under equipoise, where tribunal should closely scrutinize the conflicting medical findings. And there's such confusion because the wordings of the POSX, which provides a doctor appointed by the seafarer disagrees with the assessment, a third doctor may be agreed upon jointly within the employer and the seafarer. The third doctor's decision shall be final and binding to both parties. The provision provides that a third doctor may be agreed jointly by employer and the seafarer, and did not provide who will initiate the service of the third doctor, although jurisprudence, particularly the BRION Doctrine, provides that it is the seafarer shall initiate.